So it's an interesting assertion. You know, the Haudenosaunee were one of those that opposed the Indian Citizenship Act, and a great many of them to this day will tell you, I'm not an American citizen.
Welcome to the National Museum of the American Indian, and it's a great time to be here. It's the Smithsonian Folklife Festival, and it's an exciting year for the museum because it's a year of our anniversaries, and we're celebrating with the Folklife Festival, so I hope you've had a chance to enjoy the numerous programs that are taking place today and then, of course, over the weekend. This year is also the 100th anniversary of the Indian Citizenship Act, which declared all Native Americans born in the United States as citizens of the country. Despite the passage of the act, it would be several more decades until one of the most fundamental rights citizens of this country hold, the right to vote, was fully granted to Native people. For decades, states found ways to deny this most basic right to Native Americans in this country. But Native people advocated for this and other rights they were so often denied. With this anniversary, we reflect on their efforts and their tireless work to ensure Native communities have the basic civil liberties promised in the foundational documents of this country. This afternoon, I'm pleased that we will have a discussion about the Indian Citizenship Act featuring 3 esteemed panelists. Kevin Gover, on the far right, is the Smithsonian's Undersecretary for Museums and Culture. Before becoming Undersecretary, Kevin was a director of the National Museum of the American Indian for 14 years. He also served as Assistant Secretary for Indian Affairs in the U.S. Department of the Interior. He is an attorney who is on the faculty of the Sandra Day O'Connor College of Law at Arizona State University and served on the faculty of its Indian legal program. Next, we have Gregory Smith. He is a partner with Hobbs, Straus, Dean, and Walker, and a nationally recognized law firm specializing in Indian law. Greg has represented Indian tribes and tribal organizations as an attorney and as a government affairs specialist. His work on behalf of tribal clients has included introducing and securing passage of federal legislation, advocating for and securing appropriations earmarks, successfully advocating for executive clemency, drafting testimony for congressional hearings, preparing comments for federal rulemakings, developing legislative strategies, and preparing press releases and related publications materials. He has also represented his clients on a wide range of matters before virtually every major federal agency. And then we have Angela Riley. She's a professor of law at the UCLA School of Law. She also serves as director of both UCLA's JD MA Joint Degree Program in Law and American Indian Studies and the Native Nations Law and Policy Center. In 2003, she became the first woman justice of the Supreme Court of the Citizen Potawatomi Nation of Oklahoma. And in 2010, she was elected as Chief Justice. Her research focuses on issues related to Indigenous peoples' rights with an emphasis on cultural property and Native governance. And I'll add that both Angela and Greg have served on the museum's Board of Trustees. Angela is currently serving, and Greg just recently completed his term. Thank you both for your commitment to and support of the museum. So with that, I will just say thank you to everyone for joining this panel, and I will turn it over to Michelle Delaney, Acting Associate Director for Museum Research and Scholarship.
Thank you so much, Cynthia, and thank you all for coming and joining us for this 2024 Folklife Festival conversation on a very important topic, for all of us, and especially for the National Museum of the American Indian. And we're very lucky to have all 3 of you with us today. We'll have time for each of our panelists in this session to talk about their own interests and their own research and their own experiences in considering the Citizenship Act. And then we'll have some time for Q&A. So I don't want to delay. That was a lovely introduction from our director, Cynthia. And I thought, if I may, Kevin, have you start out with introducing yourselves and then launching into some conversation.
Sure. Well, I'm Kevin Gover. As you heard, I'm the Undersecretary for Museums and Culture at the Smithsonian. You probably have no idea what that means, but I oversee a number of the museums at the Smithsonian, including this one, on behalf of the Secretary. So I was a lawyer. I don't claim to be a lawyer any longer because it's been 17 years since I last cracked a law book. So I'm going to trust these guys to know the latest in what the law is. What I think about with the Indian Citizenship Act is how little I thought about it when I was practicing law or working for the tribes. It's just not something that came up. It sort of happened in 1924, but very little changed in that moment or over the subsequent decades for the tribes. There was little advantage to them at that point. Even as American citizens, their property remained under the control of the United States. Their children were still being sent to boarding schools. Their tribal governments were still being basically repressed or had gone underground. And so I became suspicious, and maybe Greg or Angela know better, that this was just part of the ongoing effort to transfer Indian property to non-Indian property, and that being citizens might mean we no longer enjoyed the, what shall I call it, supervision of the Bureau of Indian Affairs, which at least had the benefit of the responsibility to protect Indian property from incursion, Indian trust property. So that, I mean, you know, now, having said that, obviously citizenship became enormously important in the last few decades as the tribes began to acquire and exercise their political rights. They have become really quite formidable in several states in terms of just their right to vote, the number of votes that they can turn out in election. And so there are several Western states where the tribal vote is quite significant and can turn any given election. So better to be a citizen than not be a citizen, I suppose, but very little impact at the outset.
Greg?
Okay. Well, thank you very much. I'm Greg Smith, and I live here in Washington, D.C., and which is delightful because I get to visit the museum regularly. I am not Native. I grew up in a military family in the 1960s and 70s, Cold Warriors all, very overtly patriotic. Citizenship, American citizenship was awesome. As the years went by, I became an attorney. Actually was working 25 years ago when Kevin was still practicing. He and I worked on some matters together. But I remember in 1988 as a first or second year attorney being in a courthouse in Detroit. And my hearing was delayed. And I went over just looking around to another room. And there was the judge with a room full of people who were about to be sworn in to U.S. citizenship. And it was like out of a Norman Rockwell painting. Every imaginable ethnic group, age, race, and they were all crying. And I thought, wow, I don't even appreciate my own citizenship. So I was struck by that, and as I was thinking about this presentation, I remembered from the New Testament, Paul being arrested by the Romans for bringing Gentiles into the temple, and they went to flog him, and he said, I'm a Roman citizen. And the Roman tribune said, well, I paid a lot for my Roman citizenship. And he said, but I am born a Roman. And they all backed off. They weren't going to flog a Roman citizenship. So my notions of citizenship were that it was very empowering. And when I first got into Indian law and was reading the general texts on Indian law, the 1924 Citizenship Act comes, there's about one page. And I associated it with Native service in World War I, and being rewarded for that service by by citizenship being bestowed. I think bestowed is the right word, or really imposed, as we'll see, on Native peoples who weren't already citizens. But there actually was a separate act that handled Native veterans. But that's all I thought. And then this program came up, and much like you, Kevin, how's the 1924 Act been relevant? And when I started to dig in, I realized that I had been very naive about the 1924 Act. The Pueblos fought it tooth and nail, as did the Haudenosaunee. And I thought, well, why? And as I dug in a little further, up until 1934, it was a period where the federal government was trying to assimilate tribes. And they perceived it exactly as you described, Kevin. Is this going to cause our land to be taxed? Is it going to come out of trust status? Will we lose our rights in some fashion? And I started looking around, and I discovered something very unusual. Probably my colleagues here may be aware of it, but you've probably heard of the Dred Scott decision, where an African American petitioned the U.S. Supreme Court to set him free, and prior to the Civil War. And the Supreme Court, in its perhaps most infamous decision, said, because you are a slave, you are not a citizen, and therefore you don't have standing to bring your case in this court. Now, it happens that in the course of that opinion, Justice Taney decided to spend a few paragraphs on the question of Indian citizenship. And I just want to read one sentence from that. He wrote, if an individual, a Native individual, should leave his nation or tribe and take up his abode among the white population, he would be entitled to all the rights and privileges which would belong to an emigrant from any other foreign people. In other words, and there's more to it, but the context is, if you leave your nation, if you leave your people, if you leave your culture, you will be rewarded with U.S. citizenship. And of course, that's the exact opposite of what the Pueblos wanted to do. They fought that tooth and nail, but that's the Dred Scott decision. That was the thinking in that period of time. You can see it. It's how the Supreme Court thought of relations with Native peoples. And the Pueblos understood that very clearly as well. And so they opposed the Indian Citizenship Act. And in fact, there were earlier versions of it that were introduced in 1920, 21 by a Native congressman from Oklahoma who viewed it as, you should have the advantages of citizenship. But the Pueblos were cautious, objected strongly, I think with others, killed early versions of the bill. I reached out to a professor at Harvard who's done a lot of work on this, because then the bill suddenly passes in 1924. It's been trimmed down, and I wondered, 5 days after it passed, the Pueblo Lands Act passed. And she said that, in fact, the Pueblos had turned their attention to this other seminal bill that involves how Pueblos hold their lands in New Mexico, and so I think didn't put as much effort into the Pueblo Indian Citizenship Act. But so it's part of, I was naive about the meaning of the Indian Citizenship Act until you look under the hood. And like so many things in federal Indian law and policy, it's presented one way. And when you look under the hood, it's completely different than what you understood. And just to sort of close out, I actually was on the phone this morning with the Pueblo governors and told them I was coming over here. To this day, they fight ferociously for Pueblo sovereignty. So sort of applauding that, going back 100 years you were doing this, and we also talked about the Pueblo Lands Act. But the fight goes on, and there's this tension between two sovereigns, and I read articles like, why would Indians be U.S. citizens but not pay taxes? Or if they claim that they're really sovereign, then they shouldn't be allowed to vote in our state races. This was heard a lot back then. We still hear it today. And I was struck by that, and I just wanted to read a couple quotes, and then I'm done, from Justice Thomas, who in the U.S. v. Lara decision 20 years ago said, as this case should make clear, the time has come to re-examine the premises and logic of our tribal sovereignty cases. In other words, Pueblos are fighting for sovereignty. He questions whether there's even sovereignty. It's complicated because it's not like Greek logic. You are one or the other. The multiple sovereignty, I mean, the states are sovereigns as well. They are sovereigns, a number of them, that predate the United States. It's not a matter of logic, it's a matter of history and obligation and agreement. But he went on to write, in my view, the tribes either are or are not separate sovereigns. And our federal Indian law cases untenably hold both positions simultaneously. And of course, as Native Indian law advocates, it would be terrifying to have the Supreme Court determine that tribes are not sovereigns. A huge system is built around that, and a very important cultural protections and the right side of history. But it's complicated by notions of citizenship. And the Pueblos 100 years ago were saying, we don't want it to be complicated. We do not want to be citizens of your nation, so that there's no confusion and no taxation and these other issues. Now, 100 years have gone by, and we try to rally that vote and so forth. The last thing I'd just like to note is that my great-grandfather was in that Congress in 1924, so he voted on this bill. I have tried to find the voting record. All I've been able to learn is that the vast majority of the members of Congress on the East Coast voted for it. And they probably thought, this is a good thing, extend Indian citizenship to all Native peoples. But it's not that simple, and it's part of a much larger and longer discourse about where is the boundary line between tribal sovereignty, federal sovereignty, and state sovereignty.
Thank you, Greg. Angela?
Well, good afternoon, everybody. It's a pleasure to be here. Thanks for having me. It's a pleasure to be on a panel with my esteemed colleagues. I'm a professor, so I come at this at a slightly more academic perspective. I really started digging into the history of the Citizenship Act about 10 years ago when I was writing an article that ultimately was published called Indians and Guns. It was actually published by your local law school, Georgetown. And I was just trying to kind of figure out what was the relationship between the Second Amendment and Indian tribes and Indian people, particularly considering that on our own lands, to some extent, and we all know this is like, I spend a whole semester teaching like to what extent and how, we do have jurisdiction over our own territory and over our own people, albeit with some limitations from the Supreme Court and from Congress. And so I wanted to know, what does the Second Amendment look like in Indian country? There are statutes that purport to extend portions of provisions similar to the Bill of Rights, not identical to Indian tribal governments. That's the Indian Civil Rights Act. So I wanted to explore that. And what I learned in the process of writing that article is that in the history of the United States, gun ownership and citizenship have been inextricably intertwined. And then I would say a third layer of that has been race. So if you are interested in the history of the Second Amendment, there's some really great stuff out there. I mean, there's volumes of stuff out there. But there are some really wonderful things that talk about the extent to which, guns have been seen as a way to both empower and disempower particular disenfranchised minorities over time. And so I was just really interested to see. I grew up, probably like many of you, my dad loved John Wayne, so I watched lots of Hollywood westerns, and Indians had lots of guns in those movies. And I just wanted to know what was the backstory to that? How did that happen? And so that's really what got me interested in understanding at what point Indians became citizens and how did that relate to gun ownership, which is a complex story, which I won't go into. But I think one of the things about the Citizenship Act that I think my colleagues have already set up is that in some ways it was both necessary and the worst of both worlds. So on the one hand, given that there was such a high number of Native people who had served in World War I, so imagine, I shouldn't say imagine, we know that this happens all the time through various formations of politics and the military, but many, many people who were at that point really, I wouldn't say the height of colonization, but we're just coming out of like the allotment, we're in the assimilation, reservation period, living under dire circumstances, where droves of people voluntarily enlist and then some are drafted to go and fight for this country in a foreign war. And people often ask, why are Native people so overrepresented in the military? And the reason is because if you ask Native people, for the most part, they say, because this is our homeland, this is where we're from, this is our holy land, so why would we not fight for it? And sometimes it's more simplistic than that. People are just, there's connections between warrior culture and some Native culture, not all, and just, of course, pure patriotism and being raised in this country. So you had many people returning from World War I, and I think there was people taking notice that on the one hand, it seemed unusual, if not unjust, that American Indians were not citizens by birth in the same way that others were in the United States. There's a whole set of cases about whether you can actually become a U.S. citizen if you don't disavow your identity. There are other cases of white people who try to take on Indian identity and disclaim American citizenship. So there's a complex question. So I think that was one of the driving forces, is the post-World War I moment. And then in addition to that, of course, there had already been a good number of Native people who had become citizens because, as my colleagues note, the idea of citizenship was tied to assimilation. So if you were willing to give up your tribal identity, give up your traditional Indian ways, become white for all intents and purposes, move off of a reservation, these things were also linked to intermarriage in a variety of ways. Essentially, if you were willing to assimilate into whiteness, you could get citizenship. And part of that is tied to what we call the Allotment Acts, which were the late 1800s, of breaking up communally held reservation tribal lands for individual ownership. And many of the Allotment Acts also extended citizenship to allotment owners. So there were already a decent number of Native people who were already citizens through various other provisions, some even by treaty. And so this was just going to sort of loop in all the rest of the people. So on the one hand, of course, Native people should be citizens. As Kevin said, I mean, we should have all the same rights as any other American citizen. On the other hand, it was sort of the worst of both worlds because it was tied to assimilation and completely connected with an assimilationist objective. It was meant, in the case of at least some people, I think, as a way to begin or at least further the journey toward undermining tribal rights, undermining treaty rights, undermining tribal sovereignty, underwriting communal rights. And collective rights to culture. And in addition, states said, fine, United States government, you can afford citizenship to American Indians in the United States if you want to, but that doesn't make them citizens of the states where they're located. So state elections and state-run, mostly around voting rights, there were laws on the books until, I think the last one is 1947, but laws on the books until at least mid-century that affirmatively prohibited American Indians from voting in state elections, completely disenfranchised Native people. Again, we didn't really have the rights of citizens because our children are still being taken to boarding schools. We're still having like massive, dispossession through a variety of ways, executive order, et cetera. And so that has continued. So I think one of the things that I look at today, and a lot of people working on this, I think, is a really important point, is the continued voter suppression of Native people. And that is rampant all across Indian country, sometimes in fairly simplistic ways, like just putting polling places hundreds of miles away from where Indian people live on reservations, to even more kind of insidious forms of racial discrimination, as we saw, of course, with laws that prevented African Americans and others from voting. So I think that's one of the things that we have to deal with now, is kind of the dichotomy of, I wouldn't want to lose my American citizenship, and at the same time, I see on a day-to-day basis the extent to which American Indians don't enjoy the full rights of citizenship in the United States. And I would just say in particular, which I think there's a panel later today, is the deprivation of true First Amendment religious freedom for Native people, which continues in the United States today, and depriving that basic right of citizenship. So that's my take. Thanks.
Well, that's wonderful, all three of you, for bringing this information to us, for taking the time to help us consider it, to consider this situation that existed for American Indians in this country. I'm wondering about the presidential administration of the time. Calvin Coolidge, I believe, had a vice president, Charles Dawes, who was Native American. When it comes to wanting to get votes, I'm sure that was also of interest at the time, and something that's not really talked about much in our history classes, for sure. Something that we will probably be continuing to explore here as we look to the National Museum of American Indian to do next iterations of history and culture exhibitions. We also have a time coming up in just 2 years, in 2026, where we'll be celebrating America 250. And I think it's will be again a time to continue these types of conversations. And I wonder if any one of you could, before we take questions from the audience, talk a little bit about references to American Indians in our founding documents. Constitution, certainly Declaration. I'm not sure that everyone who's with us or will be listening to this understands that situation either.
Let me go first, and then these guys can correct me. But one of the, the Declaration of Independence was basically a list of grievances against the Crown, and an explanation of why they wanted to be independent. One of the complaints was that the Crown had failed to protect them from, in quotes, merciless Indian savages that were attacking them on the frontier. What they didn't say was that the presence of Americans or colonists in the lands on the frontier was illegal. It was in violation of the Proclamation of 1763. See that? I still got
Look
it.
at that.
Better than me.
Very good, Kevin.
And so that's the reference to Indians in the Declaration. I don't know of any others. There may be others.
That's the most famous one. Sure. You may be aware of others. Merciless Indian savages whose known manner of warfare is like wanton slaughter of women and children or something. It is an incredible slur. I've actually a couple times raised whether we could get a statement from Congress disavowing that reason. I think that's still worth exploring. It would push the issue of a founding document containing such heinous language. I'm not aware of something in what would be the founding documents. It'd be interesting to read the Federalist Papers with this in mind. There are, of course, references to Indian peoples and Indian tribes in the Constitution. And like many things in Indian law, these references can help us and hurt us at the same time. It was, Professor Riley's point about these things go both ways. They're beneficial and restrictive at the same time. I don't know.
Yeah, I mean, I think I would jump to the Constitution as a founding document, although not a precursor. But the Constitution explicitly mentions Indian tribes 3 times, and it's several different aspects. But one is the Indians not taxed, which had a lot of sort of legal and political force historically, slightly less so now. But also the treaty clause, because of the power of the Senate of the president to make treaties with Indian tribes, and then for have those to be affirmed by the Senate, which was a power that was ended by Congress in 1871. And then probably most prominently the Indian Commerce Clause, which recognizes the sovereignty of Indian nations sort of in a series of a list vis-a-vis that of the states and foreign nations. So Indian tribes are in the founding documents, and I think one of the things that as a law professor in 2024 that I find really critically important is to make my students understand is that from the very beginning of the contact between the colonizing forces and Indian nations, the concept of Indian tribal sovereignty was acknowledged and recognized. The initial interactions between colonizers, even a precursor to the United States, the foreign powers, of course, in the beginning, nobody knew what the United States was going to be or who of the foreign powers were going to emerge as the winners. So in those early colonial periods, there were treaties, oftentimes between foreign nations and Indian tribes, who were the precursor to the United States, who stepped in the shoes of those colonizing powers with relation to those treaties. So from the very beginning, there has been a government-to-government sovereign relationship. And at the Constitutional Convention, that is embodied in the United States Constitution of there are these separate things, these political sovereign bodies called Indian tribes that are treated completely differently and distinctly from any other particular group that we might have here on the continent, including, of course, enslaved Africans who have obviously their own unbelievably terrible history, but a history that is not identical to that of Indian nations. So the Constitution continues, along with the treaties, and then of course now through a whole host of Supreme Court decisions, some of which are absolutely terrible and still on the books, but really do set up the concept deeply embedded in American history of tribal sovereignty. So if you really wanted, in my view, to undermine the idea of Indian nations as tribal sovereigns, it would take a constitutional amendment, I think, and I don't think that's going to happen. I say that as like a very, very pro-Indian rights lawyer and professor. I think everybody who actually follows the law knows that the Supreme Court has managed to chip away at a lot of the things that I think are held sacred. But putting that aside, we are part of the founding documents, and I think that is part of the foundation of our structure and our security and status within the United States.
And I'm sorry.
Go ahead.
We should mention that the idea of being a citizen of more than one sovereign it should be unremarkable, since we're all members, are all citizens of the cities or towns we reside in, the counties we reside in, the states we reside in, and the United States. There's also a great many Americans who hold dual citizenship with other countries. And so it shouldn't freak anybody out that we can both vote in a tribal election and in a state and federal election.
I want to pick up on your reference to Indians not taxed in the Constitution. Some tribal members have brought cases saying we don't have to pay taxes. Those have not fared well. But it's illustrative of this point about assimilation and the quote I read about leave your nations and become cultured and civilized, and you can be citizens and have those rights. Indians not taxed was a reference. You couldn't count Indians not taxed towards how many representatives you get in the House of Representatives. Now, what Indians were taxed? The ones who'd moved into cities and towns. In other words, who had assimilated, and that was a bonus. You might get more representatives in the Congress depending on the margins. But Indians not taxed was a different category that was, in a sense, being placed outside the Constitution, those individuals. And if you were inside, you were a taxed Indian, then that was a bonus feature for the states who had significant native populations.
So in following up on being the dual citizenship, I'm thinking about the Olympics, which are coming up, and wondering how American Indian citizens have maybe carried their own passports in the past or wanted to represent their own sovereign nations. Do you have any comments on that as we see another Olympics coming up?
I'm not aware of any at the Olympics. Certainly the Haudenosaunee, the nationals seek to participate in the what's it called? The World Games, basically, the World Lacrosse Games, and compete against other countries. And so far they've been successful, although, depending on the host nation, they couldn't get into England, for example, on their Haudenosaunee passports. But at other times, I understand that this year they were excluded from the field of 8 different teams. And the Irish actually withdrew from the tournament in order for the Haudenosaunee to be able to play. So it's an interesting assertion. The Haudenosaunee were one of those that opposed the Indian Citizenship Act, and a great many of them to this day will tell you, I'm not an American citizen. And I don't know if this is apocryphal. You guys might know, but I read a story once that at least one of the 6 nations, as World War I was on the horizon, and the government announced its intention to draft Indians into the army. And one of them said, no, we're not subject to the draft, but we're going to declare war on Germany, so we'll send our citizens to fight with yours. So, they're smart, right? It's a very interesting way to assert your sovereignty.
So a couple of people that I talked to in preparing for this wanted me to ask, and I know this has come up a bit in the conversation, about learning about the Citizenship Act, the centennial coming up, and thinking about whether tribes, individual community members do feel enfranchised today.
Do they feel enfranchised?
Mm-hmm.
Well, I mean, I guess I would say yes and no. I mean, I see this coming up most often in the voting rights context, and I think there's some really great work being done. NCAI, Native American Rights Fund. There's some great lawyers out there working on voting rights issues. As many of you know, if you're from rural parts of the country, which I am, I grew up on a farm in Oklahoma. I don't know if I mentioned, I'm a member of Citizen Potawatomi Nation, which is in Oklahoma, and there are a lot of places where there are not physical addresses. Members of my family were not born in hospitals and never had proper birth certificates or documentation where voting would be possible. These things are not like far in the distant past for Native people, especially in very rural parts of the country and remote reservations. They're true of many people living in rural parts of the country, but all of the things that you see are heightened and exacerbated in Indian country. They're more remote, they're poorer, they're further away, oftentimes, and many times located within states that are hostile to Indian rights, and that are actively attempting to suppress Indian rights. I'm not going to, say anything specifically about which of those states might be, although I'll just say I've visited a few of them recently. So I think that there is definitely a sense to which Native people do not feel fully enfranchised in the U.S., both as individuals and as collective sovereigns, for a whole host of reasons. There's a very famous Supreme Court case from the 1800s called Kagama, and the language in Kagama, one of the things the court there, in sort of just making a decision about plenary power and wardship of the tribes, says oftentimes, this is a paraphrase, but oftentimes the most hostile enemies or the greatest enemies of the tribes are the states. So from the beginning, there's been a recognition that you sort of had the statesman view of Indian tribes, which is sort of the national federal government even being willing to legislate on behalf of tribes or advance tribal rights. But where the rubber hits the road is where Native people interact on the ground within states and within the borders of states that either don't want them there or want to take their land and resources. So there is still, not everywhere, some places there are wonderful working relationships between tribes and states, but there's still a lot of tension between tribes and states, and that manifests in many places in trying to disenfranchise Native voters and suppress the Native vote. So I think that's where I see it mostly playing out today.
The South Dakota tribes just banned the governor of the state of South Dakota from entering their reservation, so there's some tension there.
I've wondered, and you worked in New Mexico, Kevin. A lot of the pueblos in New Mexico do not elect their secular leaders. They're appointed by religious leaders, so they don't have an internal voting tradition. And I've historically just thought, as a non-native, that might be part of the explanation why their turnout is so low in state and national races. But preparing on the Indian Citizenship Act has made me think there's another factor here, which is just we are bound and determined not to buy into this other sovereign. I don't know if it's that intentional, because now we're out there and Pueblo leaders are trying to turn out that vote, because we have all learned that voting is perhaps the principal benefit of U.S. citizenship and state citizenship, the ability to affect the local politics. But I've wondered about that, and I think this whole presentation has given me new insights.
I have to agree with the new insights part on that, Greg. Another question that I was asked to present is, with tribal citizenship being essential to many American Indians, how does the Indian Citizenship Act function in tandem with tribal citizenship?
Kevin, you said it.
Yeah, easily. There's nothing inconsistent about being a tribal citizen and a citizen of the United States. All of us, well, not Greg, but...
I'm a citizen of the United States.
Yes, Greg is a citizen. Don't want to get you in trouble. But Angela and I vote in tribal elections, and we vote I vote in Virginia elections and Fairfax County elections and federal elections. So, that part is largely resolved. There are very few no one would dare say, you don't get to vote. They have more subtle ways of making sure that, or making it difficult to vote, but they won't tell you you don't get to vote. And so, it's really no longer contested.
Okay, well, I also want to make sure that we have time for any questions that we have here in the auditorium from our guests. There's a mic at the front of the stage. If anyone would like to ask a question, please come up right now. Great, come on down. Thank you.
Mingapo. My name is Lisa, Rappahannock Nation of Virginia. I was just wondering, because I have not done a lot of research, I'm an occupational therapist, not a lawyer, but have you all seen, as you've done your research for this talk, other acts that cropped up during the 1924 time period, such as the Racial Integrity Act of Virginia, that cropped up sort of spurred on by the Indian Citizenship Act? What other forms of oppression have you seen during your time of research?
I didn't necessarily associate the Racial Integrity Act with the Citizenship Act, but I suppose it could have been a reaction. The Racial Integrity Act in Virginia was a Jim Crow law that was intended, that basically defined the respective rights of the races. There were two kinds of people under the Racial Integrity Act. There were white people and there were colored people. And colored people included black people, Native people, Asian people, anyone who wasn't white. And when we say not white, that meant if you had any ancestry other than white in your background, you were deemed colored. And of course, that disadvantaged you in any number of ways under Virginia law. There was a prohibition on marriage between colored and white until 1967, I think. Yeah. That was only struck down in 1967. So, in a sense, these Jim Crow laws that were being applied throughout the South were also being applied in the Western states to exclude Indians from voting, from public accommodations, and all of that kind of thing.
I think I've read there was an exception in Virginia to that law for descendants of Pocahontas. And we're getting nods over here, so a firm affirmation of that. And
you know why, right?
No.
Because all of the leading citizens of Virginia had worked very hard to establish their descendancy from Rolfe and Pocahontas. And so, they're about to pass this law and said, oh my God, we're about to turn all of our leading citizens into colored people. And couldn't have that.
No. Pocahontas, just to place her in history, was a contemporary of Shakespeare. And when she arrived in England, he had just passed away two weeks before, or she might have encountered him. But these race issues also the tribes in Virginia also had to deal with these issues. It's suffused to all of society, and we see that. I'm not talking about race issues more than citizenship issues. The long national debate, but the 20s was a period. And we saw a turning point. I think the Merriam report was 1924.
28.
Okay, so that was, if you read it, it's disgusting to read, but it in fact was the foundation, as I understand it, for the 1934 Indian Reorganization Act, which was a shift in federal policy towards the notion of supporting tribes and tribal governments and moving away from this assimilation effort. So that somehow was in the mix in the 20s as well.
Well, I would throw out there, I don't think this is directly responsive to your question, but I think one of the things that I've thought a lot about in my research, and especially thinking about various congressional acts over time, some of which are intended to be remedial, and I think the Citizenship Act was to some extent, right, this outcry of like, so many Native people fought in World War I, they should certainly be citizens, is also thinking about the Indian Civil Rights Act, which is passed in 1968, which is also was the product of recognizing that the Bill of Rights of the U.S. Constitution didn't apply to Indian tribes. And I won't go into all of that, but I think that you find the same thing with the Allotment Act. Really, almost every major congressional act that you read about historically with regard to Indian nations many times is driven in part by those who see it as an instrument of assimilation and a way to get their hands on Indian lands and resources, including children. And that's still happening today. On the other side, sometimes there are people who actually think that they're acting in the best interest of Indian tribes, or more often Indian people, and sort of taking colonization as a fait accompli. And if there's nothing we can do about it, then why don't we, pass this act, which will maybe be a remedial step here or a remedial step here, with some really negative consequences. And those consequences vary depending on whether we're talking about the Allotment Act or the Citizenship Act or the Indian Civil Rights Act. But I guess one of the things that I have tried to do in my own work, and I teach my students, is just be very skeptical of when you have the imposition of laws from the top down coming on to tribes that treat tribes as homogenous, as if we all have the same goals and interests and desires. It's going to impact us all in the same way, which of course it's not. And one thing that's interesting, which you mentioned too, is the extent to which you have sometimes Native players behind the scenes as advocates for some of these laws, depending on their own particular situation, political agenda, et cetera. And so I think that's just one of the things that I think is sort of interesting to think about, is the troubling both benefits and consequences to some of this legislation. And just because, and maybe in particularly because if the dogma or the mantra is we're doing this on behalf of Indians, you're going to be better off if we do this, I would say then watch out.
Wise words, Angela. Are there any other questions? Yes, please come on down to the mic.
This is related to the earlier question. Do you know whether anybody has done a deep dive into whether the Indian Citizenship Act affected Native peoples who were not federally recognized in 1924? And I'm thinking specifically of the context of Jim Crow states.
Well, I think if you weren't federally recognized, you would have had birthright citizenship. You wouldn't have been considered a Native person, most likely, by the federal government, so you probably would have had birthright citizenship if you were born here. But that's just my gut instinct. I don't know if you have...
Mine as well. It doesn't mean you wouldn't be discriminated against, even de jure. But that would fall into that Indians not taxed category. If you weren't federally recognized, then you're not an Indian for purposes of the Constitution.
It'd be interesting to look at whether there were Indians not taxed who still strongly identified with their tribes. Yeah. I think it very probable, and yet they'd be over in this other category. In the 1920s, we didn't have this sharp distinction between federally recognized tribes and other peoples. That's a concept that's evolved and now is a very critical concept in a lot of the discussions. So I imagine it was murky who had been and who was a citizen and who was not, except where there were clear groups like the Haudenosaunee and the Pueblos who were saying, we're not citizens. They're clear themselves that they're not citizens.
Well, thank you very much. I'm being told we need to wrap up, but if you have further questions, our panelists will be around for a couple of minutes here. And I just want to thank Kevin, Greg, and Angela so much for their insights and for being with us today at the 2024 Folklife Festival. Thank you all.
Thank you.
Thank you.